It's really hard to argue self defense when you shoot someone who's lying on the ground. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. Well, I'm back in the Lori Daybell case again today, and today I was listening to the testimony of one of the detectives. And it brought me back to the 14th when the medical examiner testified. Now, I know medical terms, I understand autopsies. There's almost nothing more uninteresting to me than listening to an autopsy, but it's necessary in the course of a murder trial to get that information out in front of the jury. So, Derek Baumgartner is the medical examiner for Maricopa County. He testified the other day in the trial of Lori Vallow Daybell. She's charged with conspiring to murder her husband, Charles Vallow, as we all know. She didn't deliberately or, actually kill Charles. That was her brother. But the conspiracy arose with her. So Dr. Baumgartner told the jury that Vallow died from two gunshot wounds, including a fatal shot that pierced his heart. The timing and placement of the shots is what led to Lori being charged with conspiracy. At autopsy, Baumgartner said that the first bullet passed through the middle of Vallow's body and exited out through the back in the area of the left shoulder. He said it was a short range shot between 2 and 4 feet from Vallow. One of those rounds was found in the wall. He told the jurors that the injury was not instantly fatal and that Vallow could have remained conscious for seconds or even up to 2 minutes. The second shot, however, according to the evidence, was fired from above Vallow as he lay on the floor. Now, Vallow was killed by Daybell's brother Alex Cox, and Cox claimed self defense and was never charged. He died several months after the fatal shooting of his brother in law, apparently from natural causes. Here's the problem: the elements of self defense are fairly standard across the country. One of the most important is that there must be an immediate, deadly threat to the defender's well being. In other words, there has to be something that could either cause death or grievous bodily injury that is an immediate threat. The way it has been explained at the trial is that apparently Charles Vallow hit him with a bat.
Knowing that he had an injury to his head, did that play in? Well, let me ask you, when did you learn that?
I believe it was during the investigation. We learned that Alex had sustained an injury to his head. So with that, made us more aware of potential other blood evidence, and that's why we were looking for that.
Okay. So is that why one of the reasons why you're looking on this gun to see if there was any blood transferred from him potentially touching his injury and manipulating the gun at some point?
Yes, from our understanding, there was some sort of assault with this, or assault with a bat, and then Alex then retrieved to the bedroom to get the gun. So our understanding is if you get hit with a bat and you're bleeding, that you would hopefully bring some sort of blood evidence onto the gun, and then what happens after, there's more blood evidence as well.
Apparently, the state's theory is that the self defense claim was staged by Daybell and Cox after Vallow was shot. In other words, he was shot in cold blood, and then they made up this self defense claim. Listen to this testimony about where the bat was found.
You talked about mirrors in that room. Did you notice any cracks or damage to any of those mirrors?
I did not.
Um, Did you see the bat in the room?
I did.
Was that on Charles's right or left side?
It was on his right side above more north of his head.
Now, Cox had a head injury. The claim was that Vallow attacked him with a baseball bat. He went and got his 45 caliber pistol and shot Vallow in self-defense. There are several gaping holes in that story. First, head wounds legitimate head wounds, bleed very badly. If you cut your scalp, if you run into a door like I did several years ago, a car door, and it cuts your head, you're going to bleed like a stuck hog. That's just the way the brain is protected by that free flow of blood because the purpose of the blood is to wash away anything that might invade that wound. And so that's one of the reasons why they bleed very quickly and very badly if there is a head wound. A scalp injury sufficient to be potentially deadly as a threat would normally produce lots of blood. It would produce lots of bruising. It would likely produce some level of unconsciousness. Listen to the testimony of the police detective who was on scene with respect to the blood.
And when you are processing that room, are you looking for any potential blood evidence that's not just on or around Charles Vallow?
Yes, we are. We're constantly looking for any kind of blood evidence that would help us tell the story. Any kind of movement of somebody who had bled and then moved through the house to try to better explain what had happened.
So in this case, did you check that wood floor in that called great room for any blood drops or spatters or smears that might be on the floor that wasn't like right under Charles?
Yes.
Did you find any?
No.
Did you go into the other rooms in the house and help search for any other blood evidence?
I did.
And did you note any blood drops or smears or anything else on the flooring or walls in any other rooms?
Not on the flooring or walls. The only other location of blood that was present would have been on the faucet of the kitchen sink.
And that was that small drop right on the faucet itself? Or
I would more smear, or I would call it a drop, but yeah, there was a red substance consistent with blood on that faucet.
okay. Were you looking around the room for any towels or shirts or anything else that may have been used to, whether it was clean up or stop bleeding?
We were.
Did you find any?
No.
So, no blood on the pistol, no blood anywhere from Cox, but lots of blood from the victim. It would appear, just thinking about the state's case, that they believe Lori whacked Cox with the bat to give the appearance of self defense, but she didn't make him bleed nearly enough because apparently she loved her brother and she didn't really want to hurt him. She just wanted to set things up to make it look like he had been battered before he acted in self defense. And the lack of any sign of cleanup or staunching of blood from this head wound is evidence that the wound itself was not particularly traumatic. So, at first blush, the imminent deadly threat would appear to be missing or grossly overstated. Another element of self defense is innocence. In other words, the party doing the defending must not have provoked the issue with violence to begin with. It would appear that Vallow and Cox can make a claim that they were innocent and that because they had the children in the house, nobody was expecting to be attacked. That could be true. It could perhaps not be true. We'll have to wait for the evidence to judge that. But Arizona law requires something called proportionality. In other words, you can use the force that's objectively reasonable to repel the attack, assuming there is an objectively reasonable fear of significant injury or death. Now, the words objectively reasonable are very important because it has to appear to a reasonable person, based on the objective evidence, that there was a significant threat of serious injury or death. And one little whack with a ball bat is probably not going to be enough to set that up. Now, clearly, if the guy swung the bat very hard and could possibly have killed him, certainly that would be a deadly threat. The problem is that the physical evidence that's there in the residence doesn't really support that. You know, it's quite possible that hitting someone with a spatula or a pancake flipper could produce injury. It might hurt. But would it be objectively reasonable to believe that the pancake flipper could produce imminent injury or death? Most likely not. Which brings me to the next point, which is that in a self defense situation, every shot fired has to be justified. Consider this hypothetical situation. Bob gets mad at Andy and he threatens to harm him with cutlery. Andy draws his concealed weapon and discharges it, wounding Bob in the side. But now Andy's mad, and as Bob pleads for his life, Andy again discharges his weapon. The first discharge was justified, the second discharge was not. Thus, even if the first time that Vallow was shot was somehow justified, I don't believe that it was, but we'll wait for the evidence to see. The second shot, when he was on the floor, was clearly not justified. The state's theory will be that the second shot was there to finish the job, very much the way running over Todd Sturmer was necessary to finish the job for Linda Sturmer. The detective today laid a good foundation for this theory on closing argument by detailing what he found under Charles' body.
Now, at some point, we've heard the medical examiner came to remove Charles Vallow's body, correct?
Yes,
And were you present when that happened?
I was.
And did you and the others that were processing the scene clean up the blood on the floor that had been left underneath him?
I did.
And when you were cleaning up the blood, did you notice anything on the floor that stood out to you where he had been located?
Yes, I did.
What did you notice?
When cleaning up the blood, I immediately noticed a defect in the floor consistent with a bullet strike that would have been close to or right on this area where the exit wound would have been on Charles' left shoulder.
So you had seen the floor and been processing that room while Charles was laying there, correct?
Right.
And once his body was removed, there's a pool of blood underneath where he was.
Correct.
And in that area, I'm going to put up Exhibit 60, is where you then observed that bullet strike.
That is correct.
I'm going to put up a little bit further back of one. Hold on. Let me put up 56. Although it's harder to see, the marker itself is next to where that bullet strike is.
Yes.
So when you are seeing this, what comes to your mind at that point?
Well, in this scene, we're trying to make sense of kind of what happened with limited information. We know we have two casings, and we know we have two projectiles. We have a projectile that's into the wall, and we also have a projectile that is near Charles' body. We believe, obviously, the first shot or a shot went through and through his body, causing two holes and entered into the wall. The other shot we have is a low left abdominal entry, and what we believe, and not confirmed until autopsy, but a upper left trajectory near his shoulder. We looked through the room to where this projectile could have exited throughout the room and then landed in that spot near where Charles was. And we did not see anything until his body was removed and the blood was cleaned up.
So you're looking like walls and trying to find any other location where the bullet may have struck and bounced back and ended up in the floor there.
Correct.
And you didn't find any defects or any holes or anything other than the one bullet that was in that baseboard.
Correct.
So when you see this now, did you feel that was consistent with the bullet striking the floor underneath Charles and him being on the floor when he was shot?
100%.
Now, Daybell has not yet mounted anything resembling a good defense on these issues. The best defense to the detective today is to get him to admit that he wasn't there, that the physical evidence doesn't tell the whole story. And lawyers can do that without looking like they're downplaying the incident because they aren't the people directly involved. But when you have persons up there using I pronouns and that sort of thing, it makes it look like you're downplaying the incident, which is another reason why you should never do your own defense. You can't help but look like you are excusing your own actions when you ask questions like that. The detective today looked very much the part, like he was brought right out of central casting for this role. He looked smart in that business suit, he gave clear, direct answers, and obviously he's testified in trials before. Lawyer will get to cross him, but if history is any guide, it won't be very effective. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.